Hello everyone, I'm Anurag Thakur and you're watching Live Law. The Supreme Court on Monday has adjourned the plea of CPI Marxist leaders Brinda Karat and Tiwari seeking registration of first information reports against BJP leaders Anurag Thakur and Parvesh Varma for their alleged hate speeches during an election rally in January of 2020. The matter is adjourned to October 3 and the Supreme Court has explicitly stated that the Delhi police will not be granted any more adjournments in this matter. The case began in August of 2020, when Communist Party of India Marxist leaders Brinda Karat and Tiwari approached a trial court in Delhi seeking registration of FIRs against the BJP leaders for hate speech under various sections of the Indian Penal Code. The trial court dismissed their application for FIR filed under section 156(3) of the Code of Criminal Procedure with an observation that to register the FIR against Anurag Thakur and Parvesh Varma, a prior sanction from the government was required under section 196 of the Code of Criminal Procedure, which had not been obtained by Karat and Tiwari. However, the CPIM leaders had argued that section 196 says that no court shall take cognizance of certain offences without previous sanction. But in this case, stage of cognizance did not arise at a time of directions issued under section 156(3) of the Code of Criminal Procedure, and so no prior sanction was required for the registration of the FIR. Then they approached the Delhi High Court in a writ petition against the trial court's order. But in June of 2022, the Delhi High Court also dismissed their writ petition, observing that the petition cannot be entertained by the court in view of the settled position of law and judicial rulings on the existence of alternative remedies. Karat and Tiwari then approached the Supreme Court with a special leave petition against the order of the Delhi High Court. While agreeing to hear the plea, the Supreme Court had observed that on initial impression or prima facie, the stand of the magistrate that sanction was required to register an FIR appeared to be incorrect. Today, on the 4th of September, a bench of Justice Abhay S. Oak and Justice Pankaj Mittal heard the matter. When the matter was taken up, the Delhi police sought for another adjournment and the petitioners opposed this request. This is the third time that the Delhi police has sought time or adjournment in the matter since notice was issued in the matter, and the court agreed to hear the plea of the CPIM leaders. When the matter was adjourned the first time, in May, the Delhi police had sought additional time to file a counter affidavit to the special leave petition. The matter was adjourned again last month after the Delhi police circulated a letter requesting the postponement of the hearing. While the court granted adjournment to the matter today as well, it specified in its order that no further adjournment will be granted to the Delhi police on the next date. The court said while dictating the order, and I quote, "A prayer for adjournment made by the respondent is opposed by the counsel for the petitioners. Notice has been issued. This petition will have to be heard. For that purpose, it shall be listed on October 3. No further adjournment will be granted to the respondent." During the hearing today, the Additional Solicitor General S.V. Raju appeared for the Delhi police and also brought the attention of the court to an order passed by the Supreme Court in this very case on January 9. The first time this matter was heard by the Supreme Court, the court had directed this plea to be placed before the Chief Justice of India for instructions if the matter will be tagged with the batch of petitions seeking action against hate speech. The counsel for petitioners, however, objected to tagging the matter with the hate speech batch of petitions, saying that the plea made by Karat and Tiwari was slightly different from the other pleas in that matter. The ASG contended that previously arguments were made by the petitioners that the current plea is similar to the hate speech matter. In view of this, the court also directed the registry of the Supreme Court to seek necessary directions from the CJI on this issue. We have covered the proceedings in the hate speech batch of petitions on this channel. We will leave a link in the description to those videos if you'd like to watch them. If you'd like to read more about the case or the hate speech petitions, please visit our website at www.livelaw.in. If you found the video informative, please leave a like and tell us in the comments about your opinion on adjournments. If you like the work we do here, please consider joining our channel as a member for only ₹89 per month. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.